Everybody, welcome, welcome, welcome to our webinar here today. I'm Mark Gilfix, this is Michael Gilfix, and we want to thank you for taking some time out of your busy days to watch us, whether you're watching us live or recording later. We will make this available as a recording, but we don't even need to say it, but it's been a crazy year for everyone. The world is changing. The way that we interact with each other is changing. The way businesses are run is changing. Laws are changing. There's a lot of chaos, a lot of uncertainty. We can help with part of this. We can't help with everything, but we can help you to understand what you need to know to protect your family, to protect your assets from multiple generations. And we think that's a really important and powerful thing. We are going to take you on a journey over about the next hour to a lot of different subjects. So I mentioned before, I'll probably mention it again. We won't be able to take live questions during this talk, but feel free to submit questions via the Q&A function. We'll try to get to as many as we can at the end. And let's get going. So the topic of our discussion here today, to pull up our presentation, is, what now? In simple terms, what now? New elections, new taxes, new world. What can we do to deal with this? And as we get started, I want you to take a moment and just think about what got you to join us here today. Are you worried about your finances? Are you worried about your family's future? Are you worried about the implications of last November's election? I think we all were pretty on top of it. It was a pretty crazy election. Do you just feel overwhelmed? And we're here to help.
And it's logical that you would. I want to just take a second and just acknowledge the reality of COVID and the impact that it's had on our community, and I think on the way we look at life. It just shattered our sense of security. It made us question, what's going to happen in the future. You kind of thought you had things organized, and the next thing you know, things have changed so dramatically. And I got to tell you, we have seen so many situations where somebody fails to plan, something happens, and they leave a mess. Not just cost. I mean, cost, yes, but hassles for the family. So, these turbulent times should really remind each and every one of us that we need to have our acts together. And that's what we're going to do today. We're going to be very practical. We're going to talk about the steps that you can and should take to protect yourselves, your family. Mark will go through the agenda in just a couple of minutes. Last introductory comment is that, as so many of you know, we work very hard to be one step ahead, not to see what other people are thinking, but really be a thought leader. We're doing a lot of that today. So our goal is to turn any fears that you have into hope, give you that peace of mind that flows from knowing that you've taken steps to protect your families, the kids and those grandkids, right? That's what so much of this is about. So again, many topics we're going to discuss in very practical terms, giving you a lot of action items at the end.
Absolutely. And again, the last year has brought a lot of these issues to the forefront. So let's start diving into our content. We're here to help, by the way. We're going to go through so much here today, but we are going to give you some specific action items that you can take literally starting tomorrow, and some other longer term action steps that you really need to take. And we're going to tell you how we can help you. And we truly believe that this webinar can change your family's future. We want you to just imagine what's possible for your children and grandchildren when you take the right steps now, because there is a big fork in the road between families that understand this and take the right steps and families that put their heads in the sand and don't. These issues are real. They're going to come up, and it's up to you to take action. We want you to be empowered, and we want you to understand what you can do. I think that's just so powerful. So what is our agenda today? Well, we're going to go over the basics of an estate plan. Many of you probably have estate plans into place. Maybe it's been a few years. Many of you probably don't have estate plans. We're going to talk about what it means to get key documents into place. We're going to talk about why, if you have a living trust, why it's really important you take a fresh look at it. We're going to talk about the secret to protecting assets for future generations, from divorce, from lawsuits, and from future estate taxes. You don't have to be a billionaire for this to be really, really important. We're going to talk about Prop 19. That was kind of under the radar for many families. It is a huge deal for families who own homes and rental properties in California. We're going to talk about what it means and what you can do about that. We're going to talk about the future of the death tax or the estate tax. what it means, what you can do. We're going to define some action steps. Again, if you have questions, submit them via the Q&A function. We'll try to get to as many of those as we can at the end. Now, as we jump in, I know many of you know us. Welcome to those of you who do know us, either as clients or attended previous talks of ours. But for those of you who don't, I want to take just a moment to introduce my co-presenter here today. His name is Michael Gilfix, and I've known Michael for over 40 years because he is my dad, as is maybe obvious. Just some really key points about his background that I think are relevant to where we are today. Mike came from a small town in northern Michigan, East Tawas. He came out to California to attend Stanford, both as an undergrad, and he stayed at Stanford, went to the Stanford Law School, graduated in 1973. And I think what's really important is when he graduated from law school, he did not go to a big firm. He didn't go to a big company. He wanted to change the world. That's why he went to law school. It wasn't just to join big companies. It was to help people. And he didn't know what he wanted to do. He just wanted to find a need in the community, like a good entrepreneur. And he identified two communities that really needed legal services that weren't really getting them: older Americans and Americans with disabilities. And he went out and he created new fields of law. He literally is one of the creators of the field of elder law. He created America's first free legal aid program for the elderly, SALA, Senior Adults Legal Assistance. It still exists today in Santa Clara County, served thousands of older Americans with free legal services. And very importantly, he went around the country, he testified in front of Congress, he trained hundreds of other attorneys to start similar programs. So he's directly and indirectly responsible for helping tens of thousands of older Americans to get legal help that they needed, and he helped shape the laws in this field. Similarly, in the world of disability, he helped to create the world of special needs planning. He's instrumental in shaping these fields of law. He's a co-founder of the National Academy of Elder Law Attorneys. He started the Disability Law Center in the late 70s, in addition to SALA. He transitioned to private practice in the early 80s to support his family and to reach a different section of the community, but he's remained a leader. And nationally, he's written books, articles, he's appeared on the radio, TV, he's been all over the place. He continues to be a thought leader. And he's also been a coach of all of my Little League teams somehow through all of this, coach of all my sister's basketball teams. And he is very excited to be the grandfather of a new grandson who was born just 6 months ago. So all this is very personal for us too. You know, it's our family that we're thinking about as well. We want to extend these tools, not just to our family, we want your family to understand them as well. So with no further ado, let me introduce my co-presenter, Michael Gilfix.
Thank you, Mark. By the way, you can all imagine how cool it is for us to be able to work together, getting the next generation involved. And before I say a few more words about Mark, what's so relevant and so important is that Mark is of the next generation. And that means that in this law firm, we have other young attorneys here as well. We have continuity. We have succession. So we're not kind of one-off. We're going to do something and not be here in the future. It's only been about 40 years now for our firm, but we have a plan. We've got it together, shall we say. Mm-hmm. So about Mark. Mark also went to Stanford. He received an engineering degree. And after that, he joined one of the top 5 international business consulting firms. And when he did that, in addition to advising, or as he was advising Fortune 500 companies and major federal agencies, he developed what I would call a holistic approach, really understanding that you have to be multidimensional as you think about planning and as you advise people. And he's brought that to the work that we do here today. So I've learned a lot from Mark. That was a perspective that I didn't have. I was a lot more sort of tunnel vision, focusing on client needs. Mark brought in all these other perspectives that have made us far more effective and successful. After a few years, he decided to go to law school, obviously. He went to Loyola Law School in Southern California, where he was one of the top 5 graduates. He was chosen as the graduation speaker, where, by the way, his topic was generosity. That was the topic of the talk, which was, kind of wonderful. Since then, Mark has received a number of awards for writing, national awards for writing, speaking, sought after speaker. He's presented many webinars, seminars to attorneys. He and I together have done writing and seminars. We haven't done webinars yet, at least, for other attorneys on multi-generational planning. Because if you think about it, that's really what this is. We're not just looking at one strata, we're looking at families, which means 2, 3, 4 generations as we do our planning. So it's kind of wonderful and reinforces the work that we're doing. Last thing is that Mark is a lover of the out of doors, hiker, windsurfer, paddleboarder, and he made reference to our newest grandchild. He loves doting on that new grandchild. So very family oriented, lots of energy.
My nephew, not mine now.
Whoops.
Yeah.
Yeah, nephew. I knew that. I knew that.
Yeah, as if I get pressure every day though to create my own. So I'm sure many of you parents watching here can relate to the pressure you put on your kids to have kids, and the kids who are watching, I'm sure you get pressure from your parents to do it. Common theme.
Loving, supportive pressure.
Yes, yes. So just about our firm, we're very proud of our heritage here. We've been in the Palo Alto and the Bay Area community for nearly 40 years now. Obviously, I wasn't part of it at the very beginning, although I was a baby running around the office. And our goal is to provide extraordinary value to our clients, an extraordinary return on investment. And it's not just us. We have other amazing attorneys. It's Francis LaPole, who heads our tax practice, Nick Klingenberg and Renee Conrad, who are awesome estate planning attorneys. We work as a team. So no matter who you meet with at our team, we all work together. If there's a complex issue that one of us doesn't know, we work together on it. So we're very proud of our team and our heritage. Now let's dive into some of the subjects here. We're going to start by introducing some mysteries, because I think this is a good way to really wrap your head around how powerful some of these tools are. We're going to talk about a tale of supercharging a plan, Larry versus Wyatt. Both, imagine Larry and Wyatt is basically living the same lives. Their parents or their fathers both leave them $2 million for their benefit. Both of them during their lives endure a divorce and endure a lawsuit, a car accident that leads to a lawsuit. Larry, he inherited $2 million. When he passes away, none of that $2 million he inherited is there for his children. And of course, there's nothing there for his grandchildren, zero. Wyatt, on the other hand, $2 million left for his benefit. He also endures a divorce, also endures the same lawsuit. Imagine exactly the same. Yet when he passes away, there's $6 million there for his children. And there's $18 million there for his grandchildren. That's a massive difference over just 2 generations. What's the difference? What's the mystery?
Next one focuses more broadly on protecting assets. These are a couple of very fortunate couples. Wanda and Dave worked hard. They have property. They built up an estate of about $20 million. We have many in our community. This makes the broader point about planning. When they pass away in 2026, over $5 million goes out the window, goes to the feds in the form of estate taxes. Susan and Jim, same estate in terms of value. When they pass away in 2026, everything is already saved and passed along to the family with no estate tax exposure, none. Dramatic difference. So again, same question, what's the mystery? What happened here?
Talk about protecting the family home. Tom, Jill, and Amos, they all own a home in the Bay Area with a fair market value of $3 million, which is not that insane in the Bay Area, which is just crazy to think of. Each home has an assessed value for property taxes, a Prop 13 low assessed value of around $300,000. They've owned them for a long time. They didn't pay much for them, and the assessed value stays low even as the fair market value has gone up, meaning they're not paying much in property taxes. Now, each of them passes away in 2022, passes their primary residence to their daughter. All 3 of them. Imagine Tom, Jill, and Amos, same situation starting out, $3 million home, low assessed value. When Tom passes away and the house goes to his daughter, she decides to keep it as a rental property. What happens to property taxes? They go up to over $30,000 a year, from $3,000 or so to $30,000 a year. Jill, she passes away, goes to her daughter. Her daughter lives in the home. You might think, oh, Prop 19, if your kid lives in the home, you're good. Wrong. Here, property taxes would go up from $3,000 a year to over $20,000 a year. Amos, on the other hand, same situation, same assessed value, same fair market value. When Amos passes away, his daughter takes ownership. She might live in it, she might rent it out. Her property taxes stay at $3,000 a year. That is a massive difference each year. And add that up over 5 years, over 10 years, over 20 years, we're talking about hundreds of thousands of dollars. What did Amos do differently from Tom and Jill? What's the mystery? So we're going to explore all of these.
Yeah, we're gonna revisit these mysteries. They teach such practical lessons. It's not theoretical. These are things that you can actually do. They're palpable. So now we want to take kind of a half step back and revisit the issue of what are the basics? What should everybody do? So what we're going to do right now is kind of go through, let's call it a checklist. Do you have a comprehensive estate plan in place? Have you looked at it recently? Has it been updated? Does it say what it should say? Does it reflect what's going on in your family now or not? Does it reflect current legislation? So we can certainly obviously help you with this. This is the most fundamental work that we do. So now let's look at the checklist, at the documents that, again, everybody needs to have. So we kind of think of these as the big four, that like everybody should do these. If you have the fourth one, if you have kids. A revocable trust. I mean, it's a no-brainer. Mark will go through that in a moment. And they're not all the same, and they're not something you can just sort of pick up off the internet. You can, but you'll likely make a mess. That's where lawyers make big bucks, by the way, when people create messes like that. So revocable living trust, durable power of attorney for financial affairs. Again, we'll talk about that a little more in a moment. The advanced healthcare directive, where number one, you appoint somebody who's going to make healthcare decisions for you if you can't. And number two, it gives you the opportunity to explain how you want certain decisions made, end of life decisions, and many others. And the fourth is the Family Protection Trust, which is more generically known as a dynasty trust. It's something that we strongly recommend for everybody who has kids.
Right, and we're going to go into the Family Protection Trust in a little bit and why they're so important and why they're so powerful. I want to take a moment for those of you who aren't really familiar with living trusts, or even if you are, just a reminder of why they're so much better than a simple will. Because a revocable living trust, also known as a living trust, also known as a revocable trust, it kind of takes the place of what most people think of as a will. Now, you might think, oh, well, why don't I just do a simple will? I can literally handwrite that. I would never recommend that you do that in any case, but you could. A holographic will is valid, but why are wills so bad? Why are we so big on revocable trust? Well, a number of reasons. One is a will does not help you while you're alive. You name an executor, the executor has no role to play to help you or your family until you're gone. And then they oversee the process of probate. That's the other thing. It doesn't help you while you're alive. And after you're gone, if you just have a will, all of your assets have to go through the California court system. Now, I don't know about you, but if you love going to the DMV or dealing with the IRS, you'll love leaving your family with probate. It's a rough process. It can take up to 2 or 3 years. It's extraordinarily expensive. The fees are set by court, and you're subject to the court's calendars and the bureaucracy of the court, and it's totally public. Everybody on earth can see it. So when you see a celebrity pass away and all of a sudden you see headlines about what they had and where it's going, you might be thinking like, why do I get to see this? This seems like pretty private stuff. Well, it's probably because they did just a will, or maybe you didn't even have a will. So everything is public. A trust is a way to privatize your estate. You assign your major assets to a trust. It's actually not a big deal. You're in charge of it while you're alive. But really importantly, you get to name successor trustees, backups, who can step into your shoes if you're incapacitated, and they have the ability to manage your assets while you're alive. But if you're incapacitated, if you just have a will, your loved ones are going to have to go to court to get a court order to be able to manage your assets and your affairs if you're incapacitated. A trust kind of takes care of this already. And when you pass away, it's private. You need some expert help to deal with the trust administration, but it's not public. It can be done much more efficiently and quickly. And the fees are typically half or a third of the fees of probate. And there's a lot more we can do with trusts than with just simple wills. So just critical to have a revocable living trust. If you don't have one, you need to put one into place. If you have one, well, let's talk about why it's important to take a fresh look at that. So you may have created a living trust years ago. You might think, okay, well, I did it. I got off my butt and I did what those lawyers were saying. I did a trust. I'm good. You got to take a fresh look at it every few years. You have to make sure your backup trustees are right. You have to make sure the structure of where assets are going is right. And you have to look at the structure of your living trust. Laws have changed dramatically. The structure of your living trust, and Mike's going to talk about that in a second, can have massive implications on tax exposure for your family down the road. So Mike, why don't you talk a little bit about why it's so important to take a fresh look or add on that?
Yeah, sure. So one of the most important points for a couple is that if you did your trust more than 3 or 4 years ago, you were almost automatically advised to prepare what's generically known as an AB trust. It calls for the division of the estate into 2 subtrusts after the first death. Many good reasons for that. There really were. We did them for virtually every married couple. The law has changed. There's now an opportunity to simplify the trust. Still good reasons to keep it, by the way. So the point is to analyze it, see if it makes sense for you, to talk about the alternatives and the benefits of alternatives, and then you make a decision about leaving it as this AB trust, or should you change it to make it simpler, easier for the survivor, still capturing estate tax protections, by the way. So There are changes that can be made. There are updates that can be made that can save you hundreds of thousands, save your estate for your kids, hundreds of thousands of dollars. And we've learned that so many folks think that, oh, if I have a trust, I've avoided estate tax. Not so. I mean, for a single person, the trust is irrelevant as to estate tax planning. So, just to realize that this is a fundamental document. It doesn't do sophisticated planning. It does basic fundamental planning that is so important. We also had a comment yesterday from someone to the effect that, well, gee, if I have a trust, I avoid the problems of Prop 19. Let's just say, no, it doesn't. So again, it does many powerful, important things, but it's no panacea. It doesn't solve all the problems. Next, we'll talk a little bit about the durable power of attorney and really why you can't just you can download a 2-page form where you check a box. And I'll tell you.
Mike, can you just review what a power of attorney is for people not familiar with it?
Sure. The power of attorney is a document where you basically appoint someone and you give them authority to act for you, sign documents for you, if you're incapacitated, if you're unavailable. So it's just making sure that nobody has to go to court to establish what's known as a conservatorship, to be able to sign your name, enter into contracts, pay your bills, etc. Okay. So with the simple form, it does cover the basics, but there are many activities that often have to be exercised if you become incapacitated. And one of the best examples is tax planning. If there's a need, if your estate is larger and new trusts have to be established, you have to take steps to transfer assets, avoid estate tax. The normal power of attorney doesn't really allow you to do that. Same in the context of long-term care. We're not going to go into that topic today. Time just doesn't allow. But if you face the onerous cost of long-term care and somebody's looking at nursing home care, there are plans that can be implemented to protect assets and qualify for Medi-Cal. Well, to implement those plans, again, the basic power of attorney doesn't do it. If you're incapacitated, which is often the case if you're looking at nursing home care, the document has to be specific to give those kinds of powers. So it's protective. The fee is minimal if you do it right. Our documents, and we don't apologize, it's a good thing, they tend to be 12 to 18 pages, a power of attorney, single space. And they're not all the same for everybody, different circumstances. So, make sure you're sophisticated, comprehensive, up to date. Let's just make sure that you're protected as we go forward.
Yeah, it's the old saying, a ounce of prevention is worth a pound of cure. I mean, we're talking here, a few $100s, a few $1,000s of prevention is worth tens of thousands or hundreds of thousands or even millions of dollars of cure when we're talking about estate taxes and related issues. So,
hey, that's good. Mark is learning some of those old sayings that we think are going away with us. That's good.
Yeah, I barely remember these now. Yeah. So now let's talk about what you can do for future generations. And this is independent of your living trust. So what we're talking about is what happens after you're gone. Where do your assets go? What is the most powerful way that you can protect assets for future generations? Well, you shouldn't leave anything to your children. There, done. Now, I don't mean that in the way you might think. I mean, obviously, if you don't leave anything to your kids, those assets are, I guess, protected because there's nothing there for them. But no, instead of leaving assets to your children, we strongly recommend, and we think every family should prepare family protection trusts. So if you have 2 kids, it'd be 2 family protection trusts. If you have 3, it'd be 3 family protection trusts, 1 for each child. Again, they're generically known as dynasty trusts. Family protection trusts are our version of these very powerful trusts. Now, why does Bernie Sanders want to get rid of these? Now, this isn't a political statement. He's on record saying that he doesn't think these are fair. Well, you can look at why he might think that and why some people think they're not fair. Our job is to inform you about what's available. It's up to you if you want to do it. So there's a lot written about this. The Wall Street Journal, CNN, New York Times, you can find all sorts of articles about dynasty trusts and what they do and how they work. And I think in the past, these were tools that only ultra high net worth families created. Families with multi-generational insane wealth, the DuPont family or the Walton family or whatever, families with hundreds of millions of dollars. But it's absurd that these ultra high net worth families can build in all these protections, but normal families couldn't or didn't. And we want to let you know you can build in these protections that I think a lot of us thought only billionaires could do. So what is a family protection trust? Why would you leave money to a family protection trust instead of to your kids directly? Well, divorce rates are 50%, maybe it's 40%, maybe anyway, a lot of marriages unfortunately end in divorce. If you leave assets to your child and they commingle them at all, with their spouse and they get divorced, a lot could be lost. If you leave it to a family protection trust, it stays separate, it's protected from a divorce settlement. Two, if your child is sued, if you leave assets directly to your child and they get sued, it's fair game. Your inheritance, if it's in their name, absolutely that's reachable in a lawsuit. If you create a family protection trust, you put in a barrier. It's not technically your child's money. So someone suing them would have to break the trust to get to it. That's a pain. That's a huge protection for the assets you leave your child from lawsuits. Three, when your children pass away, and this is where you have to really think way in advance, and this is where this is mind-blowingly powerful. When your children pass away, especially if you already have grandchildren, when the assets in these trusts, or when these trusts continue for the next generation, they are not subject to estate taxes. That can save millions and millions of dollars, even if you're not starting out with much. Let's say you just own a house in the Bay Area. That alone could justify creating these, and we can already point to why this could save millions of dollars for the grandkids, because we keep it out of your kids' taxable estates. Three, you might be thinking, okay, well, this is all great, but this sounds really complicated. I don't want to tie my kids' hands. I don't want to have to work with trustees and all that. Well, your kids can be their own trustees down the road. You know, if they're young, you can put in age restrictions to say, hey, after I'm gone, if my kids are under 30, well, then someone else is going to be in charge of this for them. But if you think they're already responsible, they're already in their 30s or 40s or whatever, they can be their own trustees down the road. After you're gone, they can be in charge of their own trust. So it's a way where they can sort of have their cake and eat it too. They can be largely in charge of these assets, use it to support themselves, their families, buy and sell real estate within them, but with these incredible protections. And in California, they last for around 100 years. So you create this, and it's like 2 to 3 generations of really powerful protections. It's like a lifelong insurance policy for the next 2 generations.
And let me interject, by the way, that we've talked with so many people about these trusts. We have learned that the moms, many of you focus more on the divorce protections. You worry about that. The dads tend to focus a little bit more on the litigation protections. Both certainly appreciate and focus on the estate tax. So, there are some differences, but everybody sort of identifies and understands the value of taking this approach.
Yep. Let's circle back to one of those mysteries.
Yeah.
So Larry and Wyatt, remember, both Larry and Wyatt, $2 million left for both of them. And both of them endured a divorce. Both of them endured a lawsuit. Basically, imagine them as living the same lives. When Larry passed away, nothing was left. It was all gone. When Wyatt passed away, there's $6 million there. Why? Because Larry's father left him that money directly. So when he got divorced, a big chunk was lost. When he got sued, the rest of his inheritance was gone. There were no protections. Wyatt, on the other hand, his father created a family protection trust. So Wyatt's trust, and not Wyatt, held this money. So what does that mean? When Wyatt got divorced, well, it was separate. It wasn't lost in a divorce settlement. When he got sued, the person suing him said, oh gosh, there's an irrevocable trust. I don't want to mess with it here. I'll settle for other money. So that money stayed in his estate intact. He invested it in the stock market, or maybe owned a house. It went from 2 million to 6 million during his life, untouched by estate taxes, remember. So it doesn't matter what estate tax laws are when he passes away. That goes to his grandchildren and during their life. They take some income, but they invest it decently well. And over time, it doubles and triples. $18 million by the time it gets to his grandchildren. Massive difference. Tens of millions of dollars at stake. When you look at compound interest, when you can protect and keep that compound interest going, which is what these trusts can do, it is extraordinary how much money can grow and how much you can provide for future generations. And I truly believe that down the road, fair or not, we're the messengers. Fair or not, the families that create these types of trusts, there's going to be a big divide between the families that do this type of planning versus the families that don't. And again, whether it's fair or not, that's up to you to decide, but we want you to understand that you can do this type of planning.
We never let a webinar or seminar go by without talking about disability issues. We're not, again, it is not the focus, but we always mention it because with like 200 plus folks watching, there's, at least 15 to 30 of you have a child or a grandchild or a close relative with some form of a disability. So we'll take a moment now. Disability. The focus in this context is on whether somebody is able to make a living. Can they work? Somebody might be on the autism spectrum. There could be alcohol abuse issues, Down syndrome, who knows what it may be. But the point is that the individual is disabled because they can't work and make a living. So when that situation exists in the family, the appropriate tool, the step to take is to create not the dynasty trust, but the special needs trust. In a sentence, It's a trust that can hold any amount of money for an individual with a disability without interfering with eligibility for needs-based government programs. Income program is SSI, Supplemental Security Income, healthcare, Medi-Cal. So this is the tool to use. This is a book that Mark and I co-authored. We just updated it in late 2020. It is up to date. For clients with whom we're actively working, we give it for free. It's available, small cost, through our website and at our office. But most importantly, don't just get the book. I mean, if you have this in your family, you need to create a special needs trust that is properly drafted to protect that child.
And I think somewhat related to that, let's talk about our homes, because whether you have a child with a disability or not, I think homes are so critical, especially in high cost areas like the Bay Area or really all of California.
Yeah, and when you look at some of the numbers that Mark and I are talking about, you say, oh God, they're exaggerating, 18 million. But that's math. And we see it with our clients. Now, think about your home. The way where they're increasing in value, it's almost beyond comprehension. A $2 million house 2 years ago is worth $3.5–4 million around here these days. I mean, that's the reality. It's astonishing. So when you look at the value of your home, it's important for two major reasons as we're planning. Number one, Prop 19, which we're going to get into in just a moment, and the other is estate tax. So you don't look at the value of your estate as a static figure. It's what is it likely going to be worth at the time of your passing in the future? And again, Prop 19 created an absolute minefield, a serious problem for the integrity of home ownership, for our ability to preserve our property and pass it along to the kids, which most of us want to do. So, okay, Prop 19, alert in red letters, exclamations. This is dramatic, dramatic, dramatic. It's already gone into effect. It's effective as of February 16, 2021. Not on anybody's radar. I mean, when the vote was happening in November, there was virtually no publicity about the effect that is now so worrisome that everybody's starting to realize. Bottom line is, third bullet down, if you pass along a vacation home or rental property, your passing, there will be a 100% reassessment. So if your home, well, we'll go back to our example in just a moment and you'll see what we mean. The residents, there was an article in the San Jose Mercury saying that under Prop 19, if your child makes your home his residence, property taxes do not go up. And that was wrong. That was absolutely wrong. There's only $1 million worth of protection. So if you think about it, reassessment, you're at $6,000 now, it could go up to 30, it could go up to 50. Every year, it's a fortune. And it's going to cause many people, particularly worrisome, are those who have kids with disabilities, not a lot of money in the family, but they want the kid to be able to live in that house. That's been the only home they've known. Are they going to be able to afford an increase of $20,000 a year in property taxes? I mean, there's no exception in Prop 19 for that. It's terrible. So we'll go back to Tom, Jill, and Amos now, where we had very different outcomes. Okay, remember, Tom didn't do anything, and his daughter inherited the property. Full reassessment. It goes from $3,000 a year to $30,000 a year. I mean, that's dramatic by any measure. Okay, Jill, maybe she thought she had it figured out because her daughter did make the home her residence. So again, only $1 million in reassessed value is forgiven. So it's going to be reassessed. If you remember the value, $3 million, it's going to be reassessed at about $20,000 a year. So even if she lives in it, there's a dramatic increase. Amos, property taxes did not go up. Why? Because he took appropriate steps to avoid doing so. We had a number of strategies that we implemented before Prop 19 went into effect. We have others that we'll be looking at now. So let's now think for a moment about rental property. We talked about the residents, okay? That was our last example. Now, here we have a couple of guys, Bill and Andre, they both own fourplexes, similar situations. Here we go again. One, Bill didn't do much planning at his passing. Here we go again. Property taxes went from Butkus, $2,000 a year, up to $20,000 a year. And of course, that's going to increase annually. Andre, again, we're not talking about the residence, it's the fourplex. Property taxes remain the same. You do that over the next 20, 30 years for those who inherit, it's a fortune. It's a fortune. So we want to be attentive to the opportunities that we have here. So what can we do?
Yeah, what can we do? And And I know you might be thinking, well, just tell us what to do. Just tell us the steps, and so we can do it. I wish it were that easy. There are solutions, but it requires creating LLCs and new entities. And Francis LaPole and our team has been on top of this from the moment the law passed. We had, again, as Mike said, we had a strategy for people who went to us right before the law passed, and we were inundated to the brim. We've never been busier leading up to Prop 19. And I think a lot of people just didn't know it was a problem. We want to let you know it's a problem, and there are still solutions. Using strategies that have been used in the commercial real estate world for decades in California, we've adapted some of those, and we've added some of our own approaches using what we're kind of calling the Gilfix and LaPole Dynasty LLC. This is some of the most powerful planning we've ever done because the impact can be so massive, tens of thousands of dollars per year. We can prevent massive property tax reassessments when properties go from parents to children. There are still ways to do it. Again, we can't explain 3 simple steps to do it because it's very situation specific. We have to look at estate tax issues, capital gains tax issues, and of course, property tax issues. But we have developed solutions. So our mission here today is to let you know there are solutions. There's no one size fits all approach to this, but utilizing LLCs and other structures, we can protect your property from massive reassessments. And we just need to meet with you to understand what it is. You know, again, I wish there was some simple check the box form you could fill out to avoid Prop 19 and what you could do on your own. There isn't. And again, another area where where families who take steps to plan are going to be able to preserve real estate and keep it in the family, especially the family home, versus the families that just don't understand this. So I think one thing I'd like you all to take away from this is let your friends know about these tools. You know, let them know about these issues, because you are now empowered to understand that these are problems and to know there are solutions out there. So enough on Prop 19. I think suffice it to say, if you're concerned about this, if the fair market value of your home or your rental property is a lot higher than the assessed value that's used for, you know, the Prop 13 assessed value, talk to us. You know, there are solutions. They're extraordinary what we can do. Let's transition to a different challenge that I think many of us are going to face. Many of us don't think it's an issue, but it is, and that is the death tax, or as it's actually known, the estate tax. So this is, I think, is a funny cartoon that really hits home. I think this is the image that we have, sort of the Grim Reaper and a tax bill. What could be worse? Death and taxes. They're, you know, that sucks. Although I think when you really look, I like this cartoon, but when you look more closely at it, it's like, wait a second, is the Grim Reaper receiving the tax bill? So the Grim Reaper is going to pay it for the family? That'd actually be kind of nice. So actually, maybe this is a good thing. I'd love it if the Grim Reaper would pay my taxes. Anyway, I think the point is the death tax worries a lot of people. And it currently isn't an issue for most families, but we think it very well could become a major issue for far more families. And if you already have exposure, you really have to take steps. I mean, we can save millions of dollars if we take the right steps. So Mike, why don't you talk about some of our initial thoughts about what the last election means?
Sure. I mean, we have to acknowledge, you know, there's a change in Washington, and there are a number of tax proposals that are, some would call them very aggressive. Whether they'll become law, you know, who knows? I mean, we really don't know. There's barely a Democratic Senate, as you know, and the Democratic hold on the House is also much slimmer than it was. So again, there may be no changes, but there are changes afoot on a lot of proposals that are going to make a big difference. So let's start then by looking at what the law is today, so that we have a real understanding of where things are, and then we'll start looking to the future. So currently, this year, an individual can pass away and pass along $11.7 million to the next generation without exposure to the estate tax. That's over $23 million for a couple. So the coverage is complete for the vast majority of it. Now, if you're over that amount, the tax is serious. It's 40%. So 40% of everything over the allowable amount goes to the government in the form of estate taxes. Okay. The receipt, importantly, there's a lot of misunderstanding about this. The receipt of an inheritance is not a taxable event. It's the estate that is taxed. If the estate is not taxed, the kids or whoever, might not be the kids, whoever inherits the money, they're going to keep it. Now, we do not have, again, confusion here, we do not have an estate or an inheritance or death tax here in California. We did many years ago, but it was eliminated by a voter initiative. There's some stirrings in the legislature about this, but nothing that's salient, nothing that looks like it's going to become law. But again, we have to watch these things, and it's a moving target.
Yep. Let's talk about where it might be going. So there actually are two proposals floating around the Senate. Now, proposals, that doesn't mean they're going to become law. In fact, I think it's very unlikely that either of these proposals will, but some version of this could become law later. And this gives you an idea of what lawmakers are thinking. So there's two proposals that I've just reviewed at a high level. One is the Sensible Taxation and Equity Promotion Act. This is one that a few Democratic senators have co-sponsored. It would change capital gains taxes massively as they relate to estates. So right now, when someone passes away, your heirs benefit from a step up in cost basis. In plain English, that means that your heirs don't have to pay capital gains taxes if they sell your assets, your stock, your home soon after you pass away. It's a huge benefit when people inherit assets. If you were to sell stock that has a huge gain while you're alive, you have to pay capital gains tax on the gain. You have to tell the IRS, well, I paid $10 a share. I sold it for 20. That's a $10 gain. The IRS says, okay, you owe us 30% of that, more or less, in capital gains taxes. When someone passes away, currently, all those gains vanish. The IRS says, we don't care what mom and dad paid for that stock. Whatever the fair market value is in the date of death, that is son and daughter's new cost basis. So if they sell it, they only have to pay capital gains on any increases in values after mom and dad pass away. Now, there's some proposals to end that and to change that, and to even make it so when kids inherit from their parents, they actually have to pay capital gains when on all those existing gains when they inherit. So it could be a major change in law. Again, I don't think this is going to go anywhere right now, but this is proposed. Another one by Bernie Sanders actually is the For the 99.5% Act. Major reductions in the estate tax exemption. Currently it's 11.7 million per person. It's about as high as it's ever been in history. This talks about lowering that exemption to $3.5 million per person. So instead of $23 million plus per couple, it'd be $7 million protected from estate taxes per couple, with a major increase in the rate. Mike mentioned that it's currently 40% of every dollar over the exemption amount. This would increase it to 55% or even up to 65% for very large estates. These would also close some options for planning while you're alive, for gifting and other things. And we'll talk about some really powerful tools we have right now. So I think the point is, we don't know what will happen. I don't think either of these is going to pass right away. But let's take just one step back and look at the federal budget and where it's at. 2017, when the Republican Tax Cut Act passed, it added $2 trillion to the federal budget deficit. Because if you recall, they cut taxes, but they didn't cut spending. So they just said, we're just going to take in less money, but we're not going to spend less. So the federal budget deficit went up by about $2 trillion. And what just happened in the last year? Well, there were stimulus programs and stimulus bills passed. We spent another $2 trillion, basically, more or less, in stimulating the economy, helping small businesses, stuff that I think seem very necessary given what we're going through. But we had a $2 trillion tax cut and a $2 trillion spending bill. They don't cancel each other out. In fact, they exacerbate each other. They double each other. So the federal budget deficit is massive. So something has to give. And I think estate taxes, that's an area that's ripe for change. So we don't know what's going to happen in the near term. We see these proposals. We're staying on top of it. But I think one thing that is critical is we think it's very unlikely anything could pass that would be retroactive to the beginning of this year. The STEP Act, technically, they're trying to make it retroactive if it passed. I don't think it will. But let's say that nothing passes this year. This may be our last chance for a while to protect assets. December 31st, 2021 could be a critical date. So we just think you should take advantage of the tools that are available right now if you're even close to estate tax exposure. And Mike, any thoughts you'd add there?
Yeah, and I think what I'll emphasize is that if none of these pieces of legislation pass, which again, we think is very dubious, the level of estate tax protection, keep this in mind, it goes from 11.7 million down to under 6 million per person in 2026. That's the law as it's written today.
Right.
So right now, it's a very high level of protection. It's going to be cut in half. And that relates to the size of your estate. So, it's bigger than you think. Your estate is bigger than you think. It never fails. When we ask somebody to estimate the size of their estate, if they kind of think about it, write a couple things down, they'll say, 3 million. And invariably, it's 20 to 25% bigger than they say. Now, why? One is something we've alluded to earlier, the increase in the value of your assets. Real property being the leader in that regard. But look at the stock market. Maybe you're in on a SPAC. I mean, who knows what you might be invested in. Life insurance, unless you set up a irrevocable life insurance trust, the death benefit is part of your taxable estate. Money in your IRA, it is part of your taxable estate. You could inherit something. You could receive something by gift. So again, don't look at the size of your estate as a static number. Give it a projection. Have it, think about its growth. And again, come 2026, level of estate tax protection for a single person, again, under $6 million.
Yeah, and you can strike that future inheritance from your estate if your parents create family protection trust for you, and it's not. So what can you do without lawyers to reduce your estate tax exposure and to help your loved ones? There's some great ways you can help your loved ones while you're around and reduce your estate tax exposure where you don't need an accountant, you don't need a lawyer to do this. So here's some things you can tell your friends about these right now. You can do this right now. Low risk strategies. Well, you may be aware of the annual gift tax exemption. For the annual exemption, you can give up to $15,000 per year to as many people as you want. They don't have to be your kids. They don't have to be you can give to anybody. And per couple, that's $30,000 per person. So you can just give money away. And if it's under $15,000 per person that you're giving, there's no limit. Some of the proposals to change estate tax laws do limit this, but right now there's no limit on how many people you can give this to. So you can help people out. Just make gifts. It's out of your taxable estate. You don't have to report it to the IRS if it's under $15,000 per person. Helping out with education and medical expenses. If you pay tuition directly to a school, or if you pay medical bills directly to the hospital or medical care provider, those are tax exempt. You don't have to report those as gifts. So you can help your kids, you can help your nieces and nephews, even your friends. If you pay for tuition directly to the school, you don't want to give them money so they can pay tuition. If you write the check to the school, or if you write the check to the hospital, those are also very tax efficient ways to help people out without using up any of your lifetime exemption. So really powerful things you can do tomorrow if you're worried about this. And maybe you just want to help people out and hey, I don't have to report this to the IRS if it's below this $15,000 limit or if it falls into one of these categories. So, let your friends know about that. Now let's talk about some more sophisticated strategies that we can use and then we'll move forward. So
yeah, needless to say, I mean, we could spend 2 hours on this topic because there are so many strategies that are still viable, still available to dramatically reduce the estate tax. So we're kind of ticking a few off here. Forgive us, we just can't go into all the details. A Crummy Trust, that's the name of a family, the Crummy family. It's a court decision from many years ago. That's not meant to be descriptive. A Crummy Trust is a pretty well-known technique for making these annual exclusion $15,000 gifts to very young children or for the benefit of grandchildren. It can save a small fortune. Again, if you think about, mom and dad, and maybe there's 2 kids, grandkids, each of them can receive $30,000 from mom and $30,000 from dad on one of these trusts. It's a small fortune. So that can remove an enormous amount of money from the estate for the kids over time. It should be seriously considered. Kind of low-hanging fruit in a very real sense. This next one is the SLAP. Okay, the Spousal Lifetime Access Trust. So you're a married couple, it lets one spouse put $11.7 million into a trust for the benefit of the other spouse. It removes it from the taxable estate, takes full advantage of the current high level of estate tax protection, rather than waiting for it to go down. Now, that's a big deal, giving away that much money, but if you have a larger estate, it can be very prudent, and it's, I wouldn't say risk-free, because you never know what the future holds, but it's very powerful. Beyond that, we use family limited partnerships, a number of other tools that enable us to discount the value of gifts that might be transferred for the benefit of the next generation. You might have heard of GRITs, GRATs, LLCs. I mean, there's so many, ILITs, there's so many. In my book, which you'll see a photo of in a moment, in chapter 10, I identify about a dozen different tools that are available. So the point is, we understand them. The details are beyond the scope of a webinar like this. If you have a larger estate, or you think you will, you have to take these steps while you can. So number one, it will change in 2026. It could change at the end of this year. Some folks are being very aggressive and they're making major gifts to get the assets out of their estate this year. Is it right for you? Maybe. Giving away your money is a big deal. We do not take that casually. You have to take care of yourself as well. But this could be a fleeting, disappearing opportunity. And we simply have to acknowledge that. So again, our job for you is to make sure you understand it, give you the options, and then you'll decide whether or not you want to take these steps this year or wait and see and act a little bit later. But at least set
Yeah.
the table. You know, maybe it's the power of attorney that's got the details that you need.
Yeah, and don't keep an eye on this. But one benefit of getting to work on updating your plan now is that we're in touch with you as a team. We can start planning for this now, because I can tell you right now, if tax laws are changing, we will be overwhelmed at the end of the year. At the end of 2011, there was a potential major change in tax law at the end of 2011. And this was actually before I was with the firm. We had to turn away clients. We had to focus on just existing clients. I can tell you right now, if you see even an inkling of law change, if you're worried about this, get started now, because we and other professionals in this space will be overwhelmed. There aren't enough of us to serve everybody who's going to be affected. So take advantage of this while you can. You know, worst case, you're no worse off, but if you don't take action, you may be far worse off. Let's circle back to that mystery. So we'll go back to Wanda and Dave versus Susan and Jim. Both have large estates. You know, we don't pretend that everybody here, I wish we all had $20 million estates, but they were fortunate they had large estates. When Wanda and Dave passed away, their estate, their kids ended up losing over $5 million in estate taxes because they passed away after the 2026 change in estate tax laws. So let's assume that that's all, that nothing was changed before that. Even conservatively, they didn't take any actions. Their family lost over $5 million. Susan and Jim utilized, here we're going to say, crummy trusts and slats over time. They minimized their estate tax exposure. By the time they passed away, even though estate tax laws had changed, even though they had a large estate, everything remained in the family, saving millions and millions of dollars. So I think just to take this home, if you have an estate, a couple with an estate over $10 million, if you're fortunate enough to be there, you need to be aware of this, because we know that even if Congress doesn't act before 2026, in 2026, you're going to have estate tax exposure because your estate's going to grow and the exemption's almost certainly going to go down. If you're a single person and you have over $5 million in your estate, remember that includes your home, whether you can sell it when you want to sell it or not, retirement accounts, life insurance, proceeds, that's all part of it. You need to be aware of this. You may want to start looking at taking steps right now. You know, annual gifts, easy things to do. Paying bills for people, easy things to do. But there are so many other powerful ways we can take steps. And there's trade-offs for all this. We have to weigh capital gains tax, control issues. And we're not pretending that everybody wants to just avoid estate taxes at all costs. Like I know we're human. There are a lot of other considerations. Do you want to give away assets while you're alive? But the key is solutions exist. And we think it's just so powerful when families are communicating in a multi-generational way. And that goes back, we are a multi-generational firm, and we believe all this, it has to involve the next generation. You know, if you're not talking to your kids, if you think they're irresponsible, don't do this. You know, don't transfer assets. This is more, if you communicate as a family and if you work together, it is extraordinary what we can achieve. I mean, knowledge is power. So again, we want to empower you with this knowledge and awareness that these tools are out there. And again, just imagine what we can achieve together for your children, for your grandchildren, for future generations, if we work together and if we start planning now. And as Mike alluded to before, Mike wrote a book on this. So this is the recent new version of Beat Estate Tax Forever. It's a book that Mike originally published a few years ago. He just prepared a new updated version near the end of last year. And I think it's exceptional. If, again, as we said, if you're an existing client currently working with us, we're happy to give you a copy. And if you want to order a copy from our website, you can, but it gives an overview of what you can do. The intent of this talk is not to sell books. It's just to let you know that we have these resources. We think about this a lot, and there are all sorts of tools out there. So, okay, guys, we're coming up to the latter part of this. We're going to wrap this up fairly soon. Your head may be spinning. I mean, my head's spinning. And this is what I do. Take a breath. Let's pull it together. We are going to answer some questions. We're getting a lot of great questions here. We're going to get to those in just a moment. So feel free to submit questions via the Q&A function. But let's tie this all together. Not all of these, your family might say, well, this applies to me, not this. Maybe all these issues apply to you. Mike, why don't you talk about what you can do to protect your family?
Okay, so what can you do? I mean, what are the takeaways? This is not theoretical, so let's go through it. Okay, the basics. Is your trust up to date? Do you have a trust? Is your power of attorney sufficiently sophisticated? Again, laws have changed. You need to fine tune and update these documents. What's the lowest hanging fruit in terms of asset protection for the kids and the grandkids? this family protection trust. We do refer to it as a no-brainer. The benefits are off the charts. So that's, again, low-hanging fruit. It's something you should do or seriously consider right now. With regard to estate tax, depends on the size of the estate, of course. The larger the estate, the more motivated you may be to take some of the steps that we've identified. But the point is to have a plan, begin to get educated. You don't have to take all these any steps right away, but you do need to learn about what the options are. Okay, low-hanging fruit again, family protection trust, revising the trust, protecting your home and Prop 19. I deeply hope that you really got a handle on the impact of Prop 19. It is dramatic. It threatens home ownership. So that's a topic that touches probably 95% of those who are viewing the webinar. Again, we can deal with that. We can proactively protect your real property for the next generation in the context of property tax. So, just think about that. We're eager.
Yeah, and again, you may feel overwhelmed here. Your head may be spinning. The intent of this talk is not to say you need to understand all this. Now you're an expert in all these. The point of this discussion is to open your eyes, to help you understand what the issues are that really face most families, especially in the Bay Area, but really all throughout California, and to understand there's solutions there. There is no one size fits all solution for everybody. And anybody offering that, you got to be suspicious of, because life is complicated. Assets are complicated. These laws are complicated. Our goal is to bring it all together with you and for you. We want to help be your thought partner. We want to help advise you. Prop 19 estate tax planning can save literally millions of dollars. Think about how hard it is to earn hundreds of thousands or millions of dollars. That's really hard. It's a lot more doable to save that from being lost. As I've heard a lot of very smart venture capitalists and CEOs and financial advisors say, hey, look, like it's a lot harder to increase your income by 5x. It's a lot easier to decrease your costs or your expenses by 5x. We can control our expenses, and to some extent, we can control our taxes if we take the right steps. Take those steps. They can be worth the cost of starting and selling a small company. You can save that if you take the right steps to plan ahead. And again, I keep saying this, but imagine what's possible when we start planning ahead. Now, how can you take action? We invite you to become a client of our firm. I hope you got something out of this regardless, but how can we help you, or how can you work with us? And you can set a meeting. So we offer planning meetings. Now we do bill hourly for planning meetings. When we sit down with you to understand your situation, we don't give free, initial long consults. We want to hit the ground running. We want to know that you're ready to work, that we can start planning from the get-go. And if you'd like to set a meeting with us, enter your name and contact information in the Q&A function. Just name, phone number, email, however you'd like to contact us. That's an easy way for us to get it. You can also call our office, 650-493-8070. Our information is all on Gilfix.com. You can also reach out to Ashley at Gilfix.com. I think you might have gotten a confirmation from her, ASHLEIGH at Gilfix.com, to set a meeting. The sooner you do it while it's top of mind, you have this gift of attention right now. It's so powerful. Our attention is pulled in 40 different directions. Right now, your attention is on these issues that we believe could change your family's future. So take advantage of that while it's top of mind and set that meeting. Let us be the team that kind of takes you forward. We also want to make a special offer for new clients, for people who don't know us yet. We understand this is a big decision. So we want to offer, for a limited time, 15-minute, we'll call them fit meetings, where you can chat with Mike, me, or one of our other attorneys, just to get to know us a little bit more and to get a feel for if we're the right fit for you, if you're the right fit for us, making sense. We know it's a big decision. So if you're not an existing client, we are happy to set up complimentary 15-minute discussions. We have one request for that if you are married, that we ask that both spouses be a part of that 15-minute discussion, because we want to get to know all the key decision makers in that talk. So if you're ready to get going, or if you're an existing client, you want to explore these issues, call us, set that meeting. If you want to learn a little bit more about who we are and making sure that we're a fit, feel free to request a 15-minute complimentary getting to know us type of meeting as well.
So Mark, let me respond. I mean, we did have a couple of questions about fees. So let me just give you the
Absolutely.
flavor for fees. Again, hourly rate for meetings, we do charge, and the rate varies from, I think, $495 to $695 per hour. We are extremely efficient. And again, as so many of our happy clients who are watching know, we get the job done. We know what we're doing, and it's efficient. Documents for a revocable trust for a married couple. Usually, not always, but usually the fee is between $2,800 and $3,200. It depends a little bit on the structure, the terms. Sometimes it's a little bit more, sometimes it's a little bit less. Single person, it's a lot less, $2,000 or less for a revocable trust. We talked about the special needs trust. That is typically about $2,900. Our fees are reasonable. We know what we're doing. Very, very high level.
Yeah. Family protection trust about $3,300, and if we're doing multiple trusts for multiple kids, we reduce the cost. And we get this question a lot. Well, do I do a living trust or a family protection trust? Living trust is for mom and dad. That's what you would create. If you want to create family protection trust, those would be for your kids. So you leave money when you pass away. Instead of leaving assets to your kids, you would leave them to these separate standalone family protection trusts. Some of the most extraordinary investments that you'll ever make.
So I don't want to distract from those of you who just want to enter your phone number and all that, but a really good question, by the way, from somebody, I won't give names, is we don't have kids, but we're leaving all or most of our estate to nieces and nephews. Can we set up the family protection or dynasty trust for them? Yes, you can. It's really generational. It does not have to be your kids. So many folks do that. So that was kind of an insight on your part to even ask that question. That's right.
Yeah, another good question from Keith. Are family protection trusts broken by litigators? We mentioned that leaving assets to these trusts provides litigation protection. The law is not certain. Nothing is certain. There is no asset protection tool that is 100%. What we can say is having assets in a family protection trust provides a barrier that someone would have to fight to get through. Now, could they eventually get through it? It's possible. There's not much case law about it, but it is a huge disincentive for someone to go after that money. So much of the law is about incentivizing people to settle for pennies on the dollar. So it provides powerful protection. Nothing is 100% guaranteed, but they are very, very powerful. We have another question about should we wait until near end of year to see if the estate tax exemption is reduced this year, or if it might be retroactive to the beginning of the year before we take steps? Should we wait to see what happens? It's up to you. Certainly, if there is a retroactive change, which really has never happened, at least in recent history, where they've passed a law that says, oh, whoops, we passed it, and going back to the beginning of this year, you have to pay a new gift and estate taxes. We don't think there will be a retroactive law change. And of course, if there is, there's only so much we can do. I think it's far more likely that if there's a change in law, we will see that it's happening next year or the year after that. And there's really no harm in starting to plan now. We have also a question, what if laws change? What happens to our tax planning? Well, we can't predict how laws will change. What we do know is right now we have historically great opportunities to protect assets and keep them within families. And I believe it's far more likely than not that these will go away. So it's kind of like if the family's all on the same page, it's that multi-generational planning issue. Hey, take action. You don't have much to lose and you have a lot to gain. If laws change in the future, it is what it is. We can't predict that, but we know what we have right now. Other questions you want to
I think we're a little bit over that hour. So look, I got one more, and I think we should really wrap it up. Okay. So Jerry and Steve, good question. Under Prop 19, can the child sell the family home right after the death of the parent without having to pay estate taxes? Okay, there's three taxes that question raises. If the property is sold, the Prop 19 issue disappears because there's no ongoing property taxes. So that's property. So Prop 19 really has no impact if you sell. If it's sold shortly after mom passes away, there would have been a stepped up basis. So there's no capital gains tax. The question of estate taxes goes to the value of the total estate, not just the home, but everything that's added up. So again, that question raises three tax questions. And I think that's a nice, succinct answer.
Yeah, and one question I just do want to answer as well. Is there anything we can do about Prop 19 since the law already passed on February 15th? Yes, absolutely there is. It's a little, as we talked about, it's a little more complicated than what we could have done before it, but absolutely there are solutions. And the stakes are really high. That's where the Gilfix Loophole Dynasty LLC can come in. So absolutely we can still help. One last question I do want to address. I'm a widow with 3 kids. Would it be an irrevocable trust or family protection trust for each child, or both? So if you have 3 kids, you want to protect them, it would be one family protection trust for each child. They are irrevocable trust. The term irrevocable trust can refer to so many different tools, but absolutely be one family protection trust per child. So we've gotten a lot of wonderful requests to set meetings. So we will reach out to you if you sent that in. You can also, of course, reach out to us via our office, via email to Ashley, or via email as well. Call us, let us know. But we hope you got something out of this. Again, these are just crazy, crazy times. And there's so much that we can't control between the coronavirus, political upheaval. There's so much going on. In California, we have fires too, just to add to it. Great. But there's so much that we can do. So thank you so much for attending this. We hope you got a lot out of it. We hope to get the chance to serve your family. But if nothing else, tell your friends about these issues. Knowledge is power. Hopefully you're empowered now. We hope you guys all have a great rest of your days and week. And we hope to talk to you guys soon. So thank you so much from
Thank you
us
all.
and to you guys. Thank you.